We have an update in the Nevada case. Stephen Sharif just filed a sworn declaration, as did John Moore. Together, they've filed a full opposition to TFE's request for a temporary restraining order. This is the first time we're really seeing Sharif lay out his version of what happened in regards to the Nevada lawsuit. However, it does align with his own federal lawsuit in California. As always, I will link the legal documents in the description, so you do not have to just take my word for it. I encourage you to read for yourself. Also, these are allegations, not proven facts. Proof will come through the legal process. So, with that being said, let's get into it. So, what is even happening in Nevada? Well, in case you're unaware, here's a quick recap. TFE went into Nevada court and asked for emergency relief. Specifically, they asked for a temporary restraining order, now being treated as a motion for preliminary injunction. So, what are they asking for? Well, they're claiming Stephen Sharif is improperly holding company records and that he might destroy them. They want the court to force him to turn over access credentials and company records immediately. And to get that, TFE has to prove that they are likely to win on the merits. They'll suffer irreparable harm without intervention. The balance of equities favors them, and that it's in the public interest. Now, Sharif has responded. The very first thing that Stephen Sharif argues is that Nevada shouldn't even be hearing the case. He says Nevada lacks personal jurisdiction over him. And here's what he states under oath. He is a California resident, has lived in California for years, that Intrepid was incorporated in California and headquartered in California, that business operations also occurred in California, the UCC filings were filed in California, that he did not negotiate or execute agreements in Nevada, that he does not own property in Nevada and does not maintain a Nevada office, bank account, or mailing address. He even addresses something interesting. He was apparently listed as a manager of a Nevada LLC called Network Pro. Sharif says that this entity was set up by his mother, that he never signed anything accepting that role, and that he didn't even know he was listed. That's significant because if Nevada lacks jurisdiction, this case could collapse before it even gets to the foreclosure fight. This is not a minor argument, this is a foundational one. Next is the core accusation. TFE is claiming Sharif is improperly detaining company records and possibly destroying them, and Sharif flatly denies that. He says that he has not deleted, destroyed, altered, or concealed any company records, that he has no intention of doing so, and that TFE has not identified any specific missing record, and that many of the records are stored on third-party cloud platforms with built-in redundancy. He also says having access credentials does not equal wrongful detention, and that's important. He's reframing this as they're trying to weaponize access credentials as leverage. And then he makes a key argument. He says forcing him to immediately turn over credentials would effectively decide the validity of the foreclosure before that issue is litigated. Now we get into the explosive part. Sharif lays out a detailed narrative about Robert Dawson and the board. According to Sharif, Dawson became a principal lender and later majority shareholder. After a multi-$100 million acquisition offer in late 2022, Dawson's conduct allegedly changed. Sharif claims Dawson pressured him to relinquish equity and control. He alleges Dawson made demands for additional ownership interests and governance concessions. Sharif says Dawson threatened to withhold payroll funding, shut down the company, cause financial ruin, pursue litigation. He even alleges that Dawson instructed others to threaten him and his loved ones with physical harm. Then Sharif claims Dawson consolidated control over the board by installing allies. He says new bank accounts were opened without his meaningful input. His access to company financial authority was restricted. Steam revenues, specifically valve revenues, were diverted or attempted to be diverted toward accounts associated with TFE. And then we get to the Article 9 foreclosure. Sharif describes it as a plan devised in 2025 to foreclose on Intrepid's assets under Dawson's junior lien. He says it was undertaken without proper notice to the senior secured creditor, Commerce West Bank. He says it was structured as a private sale, no public marketing, no competitive bidding, no broker involvement. He claims Intrepid's core intellectual property was transferred to TFE in a self-interested transaction. He says he alerted Commerce West Bank on January 15, 2026, and shortly after, he resigned from the board. That's his narrative. It's now on the record. Sharif also reminds the Nevada court that there is a parallel litigation already happening. On February 14, 2026, he filed a shareholder derivative and direct complaint in the Southern District of California. That case challenges the foreclosure itself. The claims include improper foreclosure, commercially unreasonable disposition of collateral, trade secret misappropriation, breach of fiduciary duty, corporate waste, civil conspiracy, intentional infliction of emotional distress. So Sharif's position is the ownership of the IP is already being contested in federal court. You cannot use a Nevada TRO to short-circuit that dispute. Beyond the declarations, there's the formal legal brief. Here are the core arguments. First is no personal jurisdiction. We already covered that. If Nevada doesn't have jurisdiction, nothing else matters. Second is no likelihood of success on the merits. TFE claims it owns the records because of the Article 9 sale. Sharif argues that the foreclosure is disputed. Its commercial reasonableness is contested. And notice to senior secured creditors may have been deficient. If the sale is invalid, TFE doesn't automatically own the records. Therefore, TFE cannot show clear entitlement. 3. No irreparable harm. TFE must prove irreparable harm. Sharif argues there is no evidence of destruction. No specific record identified as missing. Cloud-based storage reduces risk, and that monetary damages would suffice if harm occurred. Without irreparable harm, a TRO should not be granted. And fourth is the balance of equities. Sharif argues forcing immediate turnover would prejudice ongoing federal litigation, effectively validate a disputed foreclosure, grant extraordinary relief before ownership is resolved. He says the equities favor denying emergency intervention. So what happens now? Well, the Nevada court has to decide. Does it even have jurisdiction? Is there an emergency? Is there actual irreparable harm? If the court denies the TRO, TFE loses immediate leverage. The foreclosure fight becomes central, and the California federal case becomes even more important. If the court grants the TRO, then TFE gains practical control over records. Sharif loses leverage, and it could influence the broader litigation landscape. This is not just procedural maneuvering. This is a fight over narrative, control, and timing. This is the first time we've seen Sharif's detailed sworn version of events in Nevada. It includes jurisdiction challenges, direct denials of record destruction, allegations of coercion and self-dealing, claims of commercially unreasonable foreclosure, and a clear strategy to push this fight into federal court in California. The Nevada judge's ruling on the TRO could shift momentum dramatically. We are officially in multi-front litigation territory now. As soon as we get the court's ruling or a hearing date, we'll break that down next. This is far from over. If you want to keep up to date, or maybe you're just curious, give me a follow, and I'll see you next time.